just let me grab mine. Rise.
The answer to my Lord Justice Snowden's question is clause 7.13, which is at page 547 of the judgment of the shareholders agreement, and there's a provision to identical effect in Article 17.7 of the Articles of Association.
Sorry, so just go, Article, sorry.
7.13.
Of the articles.
Sorry. This is the shareholders agreement.
Yes.
If you want to see the
no, but you said you gave us a reference for the article.
17.7.
17.7.
Which is at page 624.
Yep. So can I just read 7.13?
It's 17.9. Yeah, 17.9.
17.9.
Article 17.9 at page 624. Now,
sorry. The question you're you're answering is, what article do you rely, or what provision do you rely upon to found the requirement to allow the minority to appoint directors if Dr. Sachs dies?
Yes, but also to support the proposition that it was part of the agreed purpose that there should be a restraint on the removal of Dr. Sachs and Mr. Faulkner. So it's both purposes. If you've read it, I mean that in my respectful submission is an extraordinary provision, the only purpose of which, and here in my respectful submission, if I have to satisfy the principles for implying terms, I satisfy them, that it wasn't open to the investors by majority vote to remove Dr. Sachs and Mr. Faulkner in order to defeat clause 7.13.
But elsewhere in the same document, there's a recognition that you can cease to be a director under the Companies Act, or specifically the provisions allowing shareholders to remove someone.
Yes, but I mean that was something that, as a matter of company law, could not be removed, and the agreements therefore recognise that, as they have to recognise that.
So wait a minute. So I'm struggling to keep up. If Dr. Sachs dies, yes.
Yes.
Are you saying that 713 is inoperable, or are you saying that you imply a term that somebody else is appointed in his place and takes on the role of, quotes, founder director, or what?
Could I take that in two stages? First of all, if he dies, that's one eventuality. But my principal submission is he can't be removed. That the investors can't use their majority voting power to remove him because they want to get rid of that provision.
I mean, there might be three problems with that. One, it doesn't say it. Two, the articles recognise the possibility of somebody being removed under the Companies Act. Three, it's so commercially improbable that the investors should have been agreeing that there were no circumstances in which they could remove Dr. Sachs short of misconduct.
Well, in my respectful submission, if one has regard to the factual matrix, the Dr. Sachs was the jockey that the minorities were backing.
And quite, everybody hoped that he would produce the goods. But it seems so unlikely that the investors intended to bind themselves to keep him in place if that went wrong.
Well, in my submission, that is that still begs the question of the circumstances in which he was to be removed. If he were to be removed in order to defeat 7.13, then in my respectful submission, that would be a breach of the duty of good faith.
He wasn't removed in order to breach Clause 7.13. He was removed for the reasons identified by the judge.
But, my lady, he was, but it was, as I will come on to shortly, it was the beginning of a continuum whereby the majority decided that the Constitution was obsolete and that thereafter they were going to ignore it. And this in particular was a provision that they would have found by March 2016 as unacceptable.
But, sorry, the premise of your argument is that it's clause 4.2 and the good faith provision within it, which acts as a prohibition upon the use of the Section 168 power to remove Dr. Sachs. We saw that. That's the cornerstone of your submission.
Yes.
So we are looking at interpreting that clause. What does it mean?
Yes.
And what you're saying is fidelity to the bargain is part of good faith and therefore restricts the right otherwise given to remove.
Yes.
Yeah. I'm sure you're going to take us to 4.2 in a minute, but to pick up my lady's question, if one's interpreting 4.2, the normal way you do it is to ask, well, let's test a few hypotheses as to what might happen in the future. And you'd say, first, that they couldn't just at a whim, 2 or 3 months after signing the agreement, just decide, oh, well, whatever, we'll just remove Dr. Sachs because we just don't like him anymore.
Or we don't like the fact that he's got a veto.
Yeah, okay. Yeah. At the other end of the spectrum, and it was a question that I raised yesterday and it got sucked into a factual issue, but let's assume that the company was on the verge of insolvency and the directors or the shareholders formed the view that the only way to avoid insolvency was to change the management. Are you saying that clause 4.2 prevented that?
Well, my first answer to the question is that the whole purpose of a good faith clause was to be flexible so as to respond to the particular circumstances. It's not a black letter clause saying you cannot be removed.
Okay, but you're on.
It's a general agreed common purpose. Right, it's flexible. But so in those circumstances, I would be bound to accept that there wouldn't be bad faith in those circumstances. That if in order to save the company from insolvency, if there was a real risk of that, and that and that it was a proper solution to that problem that Dr. Sachs be removed, then I accept that that would not be acting in bad faith. It all depends on the circumstances. Whereas if, at the other end of the spectrum, which is, in my respectful submission,
And sorry, just to tease that out, you put it in a sort of objective bystander way. What if we're talking about the good faith or bad faith of the investors, who you say are bound by 4.2, if in good faith, on reasonable grounds, they believe that the company's survival depends upon the removal of Dr. Sachs, are you saying that that is okay within clause 4.2?
not without consulting with the minorities, because the minorities have a legitimate interest.
So does it all boil down to consultation then?
It may all, yes. Yeah, I mean, non-consultation is certainly part of it.
But what I said it all boils down to.
It may ultimately all boil down to consultation.
Well, okay, but I actually, so you're accepting it could happen, but consultation is required.
Well, consultation is the minimum requirement, we would say, of good faith.
Yes, but you're not saying that 4.2 in those circumstances that I postulated prohibits removal.
Well, prohibit is, in my respectful submission, too strong a term, given that we're dealing with if you say would fall foul of good faith, I would say, in my respectful submission, yes, but the circumstances would not justify relief under Section 994. They weren't alone sufficient. They weren't alone sufficient to justify relief under Section.
Sorry, I'm not sure I'm following. The simple question is it a breach of the agreement? This is your claim. You said is a contractual claim.
Yeah.
What I'm saying is, and try to do it in stages. Do you accept that in the circumstances I postulated, it would not be a breach? Sorry, that removal is possible, i.e., removal would not be breach, would be a breach.
If one leaves aside consultation, and if one leaves aside in our submission the duty to have regard to the interests of minorities, I would still have to submit it was a breach.
So just,
but but in my respectful submission, the circumstances here are much stronger.
Yeah, but I'm testing.
Yes.
You are trying to argue for a particular interpretation, i.e. what the parties, if somebody had tapped them on the shoulder at the point they signed it and said, what does that mean? How does it operate in these circumstances? That's what we're postulating. That's a way of doing it.
Yes.
So if you accept that it doesn't prohibit removal, absolutely prohibit removal, you say it allows for it to happen, but it has to happen following consultation and taking into account of the interest. Is that?
Yes. That is all in my respectful submission I have to establish here, because that did not take place. There was no consultation, there was no regard, and they had, even at the time of Dr. Sachs's removal, formed the desire to sweep away the provisions of the Constitution, regardless of what they were.
so can I just try to be clear? We suppose that the investors decide that they want to remove Dr. Sachs. You say, well, they can't do it at all without consultation and regard for the interests of the minorities.
Yes.
I don't know, suppose that they've satisfied those requirements. They have an untrammeled right then to remove if they have consulted and thought about the interests of the minorities.
And we would go slightly further and say had offered to appoint a replacement for Dr. Sachs. But leaving that aside,
good faith.
I think I would be in difficulty in saying that if they'd done all of that, then it would have been a breach of the duty of good faith.
The duty of good faith is those very simple words in 4.2 are doing a lot of heavy lifting in terms of writing a lot of things into the relationship, which the otherwise heavily lawyered documents don't attend to.
Well, otherwise they mean nothing.
Well, no, they don't. It's not that they mean nothing. I mean, they still, for example, can mean a duty to act honestly.
But as Mr. Justice Leggett, as he then was, says in Yen saying, nobody ever puts in a duty to act honestly, because it goes without saying.
Well, they did put in a duty to act in good faith, as we've seen in this case, and
you see,
it seems to be quite common.
Isn't the point? Isn't the point that if you're writing an agreement, especially between two very disparate groups of individuals coming from different backgrounds, investors, minorities, different countries, certainly to insist on writing in a clause that says you must act honestly might be regarded as not a very promising start for a relationship, because it sort of almost by implication suggests that you don't trust each other. Writing in a provision of good faith is something that might be regarded as more palatable. But even then it is doing something, because it is making explicit what otherwise might be thought to be at best implicit, but in fact probably not necessarily there at all between two disparate groups coming together. It does something.
Well, on the authorities, which I'll take, which you're well aware of, which are cited, it all depends on the context. That a good faith clause may mean in some contexts no more than expressing what would be the case in any event, which I think is what my lord is suggesting. In other contexts, it means much more than that. And in our respectful submission, given this context, which is the context which the judge summarises in his judgment at 387 to 389, where there is a new funder coming in from another country, not a financial institution, individuals who are not known to the other shareholders. There are risks. There are risks entailed of things, particularly of those investors deciding that they're going to take over the company. And in our respectful submission, that is what the good faith clause here was on any fair interpretation intended to prevent in a soft way, because it would all depend upon the circumstances in which it happened. But if the majority, as here, just say, we've pumped hundreds of millions of dollars or pounds into this company, and we don't think, and basically, it's all Dr. Sachs's fault, although he may not have done any wrongdoing, but we don't want him anymore. Therefore, and this is what happened, they treated the company as their own. That, in my respectful submission, is just the sort of circumstance that the parties would have had in mind at the time that they made the contract. So if these circumstances, as found by the judge, had been raised in the way that my Lord Justice Snowden suggests at the time of the reaching the agreement, they would have said that's just the sort of circumstance where, at the very least, they should have regard to our interests, should consult with us, and should offer us or consult with us over replacements. Because otherwise, we are without board representation.
Of course, that's a little odd because they're not a class. But
Yes.
Leave that aside for a moment. Just so I try to be clear about what the case is. One element of the thinking is that there has to be fidelity to purpose.
Mm-hmm.
If I've understood what you've just been saying, the purpose doesn't necessarily require Dr. Sachs and Mr. Faulkner to be on the board.
Correct.
And that's so regardless of whether the interests of creditors are intruding, there could be other circumstances in which it would be legitimate not to have Dr. Sachs and Mr. Faulkner on the board.
Yes, it would all depend upon the circumstances. The question is, and I'll come on to the findings here. The circumstances here are the investors deciding as early as the decision to remove Dr. Sachs that they were going to ignore the Constitution before all the problems over Faulkner.
Did the judge actually find that?
He did. Yeah.
What? In terms, he said they decided they were going to ignore the Constitution and then remove Dr. Sachs.
No, at the same time as they removed Dr. Sachs. Okay. No, I can't link it. I can't link it to the removal of Dr. Sachs, but it is. They had other reasons for removing Dr. Sachs, but at the same time, they had decided to ignore the Constitution.
But when you say that,
that's paragraph 417.
They decided to take control.
Yes.
Yeah.
Yeah. Well, perhaps it would be best to let you develop your submissions rather than.
Yeah. I mean, certainly coming on to that, but it's clause 7.13 that, which is the most peculiar and unique provision of the agreements, which in our respectful submission must give rise to some restraint on the removal of Dr. Sachs and Mr. Faulkner. And obviously, Dr. Sachs and Mr. Faulkner are slightly different, and it depends upon the order in which they are removed. Because once Dr. Sachs is there as the boffin, that he's the jockey that the minorities are backing, Mr. Faulkner isn't there as the boffin. He's just there as the person. He's called the founder director. He's there as the person who's introduced all of these minority investors into this investment. That he's there to represent their interests. But once Dr. Sachs is removed, then Mr. Faulkner's position becomes even more important to the minorities because he is the only representative of the minorities who remains on the board. But he, under the articles, is still in a position to veto any board resolution. I mean, he's obviously bound by his fiduciary duties to the company to act responsibly, but subject to observance of his fiduciary duties, he can veto anything.
Just picking up the point my lady made, and in relation to 417, which was the point that I think you...
Yes, the last sentence. Yes.
Last sentence. So, where the judge says, on the contrary, the evidence is consistent with them having a desire to sweep away the constitutional restrictions which inhibited them from imposing on CPGL their own view of what was required commercially. Yeah. Now, the constitutional restrictions that the judge is there referring to are what?
7.13 in particular. Because that gives Mr. Faulkner and Dr. Sachs the power to veto. He doesn't specifically refer to that in that context, but that is the most powerful.
So not 4.2?
But 4.2 is in this context a soft.
I suppose 7.13 is more like a constitutional restriction, and
yes.
Good faith clauses are some other sort of contractual restriction.
Yes. I mean, there is no doubt in our respectful submission on the findings of the judge that with effect from the strategy meeting on the 12th and 13th of March 2016, from then on, the investors had decided to sweep away the Constitution.
So you say that 7.13 prevents removal of Dr. Sachs, even if the investors genuinely believe that what is required commercially to save the company or to prolong the company in existence is his removal.
No, I don't. No, I don't say that. I say that I accept that the reason for Dr. Sachs's removal was the reason found by the judge, which was good commercial reasons.
Yeah.
But at the same time, so the sweeping away of the Constitution starts at the same time as he's removed. And I repeat the answers that I gave to my Lord Justice Newey about the circumstances in which he could be removed. And I said that if Lord Justice Newey, if there had been consultation, there had been regard to the interests, and there had been consideration of replacement, then there wouldn't have been a breach of the good faith clause in the removal of Dr. Sachs. Now, the judge may have gone even further on one reading of his judgment and said, well, actually, you couldn't remove him at all unless you showed misconduct. Now, he may have gone too far, but in that respect, which I don't concede, but it seems to me that it's a conclusion open to this court. But that doesn't stop his findings standing in respect of the exclusion of Dr. Sachs on a more narrow ground. And it certainly does support his finding that the removal of Mr. Faulkner was a breach of the duty of good faith, because there were no good commercial reasons, such as in the removal of Dr. Sachs for Mr. Faulkner. He was removed because he was a pain in the neck, which isn't a good enough reason. He was removed because he was exercising his rights under the Constitution. He was consulting with the minorities. But even if one leaves aside the actual removals of the two men and just look at what happened in the period between the removal of Dr. Sachs and the removal of Mr. Faulkner, during that period, Mr. Faulkner was the chairman of the company, and he was the sole director of the wholly owned subsidiary CPUK, which owned Newton Aycliffe, and he was completely sidelined. And on occasions, information was withheld of him, and on occasions, he was lied to about.
Just as to the lied to bit, I haven't been back to it. I had in mind that the judge rather acquitted the investors of that.
Well, he accepted that the critical email was sent by Mr. Bolger. It's 459 to 461.
And at 461, he says he accepts that neither the investors nor their appointed directors were actually aware.
Yes, but he goes on to say that it was symptomatic of the trashing of the Constitution.
I mean, I followed that,
Yes.
but when you say it's not just general trashing, but there was lying to
Yeah.
Mr. Faulkner,
Well,
that's not something that the investors are
no,
said to be implicated in.
no, and I accept that, and nor were the rather strange thing. Mr. Bolger when he sent the doctored presentation to Mr. Faulkner, he copied in the directors. So that was undoubtedly conduct of the company's business. It was copying in the directors. They said they never read it, and that evidence was accepted. But that doesn't matter, because it was conduct of the affairs of the company by the chief executive officer.
You accept he was the chief executive officer?
De facto, yes. We argued he was a de facto director, but we lost on that. Yeah, he was appointed following the strategy meeting on the 12th to 13th of March. It was Mr. Fletcher who said Mr. Bolger should be the CEO, and Mr. Bolger became the CEO. It was Mr. Fletcher's decision. There was no board meeting. There was no shareholders meeting. There was no consultation with the minorities.
So do you accept that the judge, at the end of 404, when you say the judge may have gone too far, did you have in mind, for example, what he said at the end of 404?
Yeah, I accept you may find that he's gone too far, but his finding should still stand, because there was, as he found, there was no consultation with the minorities, no regard to their interests.
Did he actually find there was no regard to their interests? I'm not so sure about that.
Let me just check my...
I think it's possibly the next paragraph, isn't it? 405.
I think it's 413, my
Is
lord.
it middle of 405?
Yes, 41, yeah.
You're right, he does say that, but elsewhere he seems to tie it to the Constitution.
Yeah.
But yes, it's 405 and then 413.
And if it helps, can I remind your Lordship of paragraph 429 on page 175, which is in relation to the separate question of breach by the directors. You may have been thinking of that.
So 413 he starts dealing with the question of failure to take into account interests.
Yes.
And 416 he says they held the view that it was in the interest of the business for Dr. Sachs to go, and that may have been a sound vision, but the Constitution was designed to avoid the will of the majority prevailing. Now, does that amount to a finding that they disregarded the interests of the minorities?
Well, he found as a fact that they did.
Sorry, where?
At the end of 415, I have seen nothing to suggest that the investors took account of any of these factors in deciding how to deal with Dr. Sachs, but they did. From their point of view, and I'm sure that if my clients were sitting behind me, they'd be saying that's the most important thing. From their point of view, removing Dr. Sachs was a seismic event, not only in the sense that it would result in the loss of his technical expertise, but also in the sense it would remove from the overall constitutional structure one of the two key individuals whose role on the board was expressly designed to counteract the possible effect of overbearing majority control, which is clause 7.13. And if you take that finding with all his other findings, that they had decided to bin the Constitution as it stood, that, in my respectful submission, is a finding that should stand, even if the judge went too far in saying that in no circumstances, short of misconduct, could Dr. Sachs be removed.
As I understand it, you rely on clause 17...
7.13.
7.13, sorry, as a way of informing the meaning of good faith in 4.2.
Yes.
Right. Can we... Are you about to go to 4.2, or can we look at 4.2?
No, by all means, 4.2.
Because one of the points my Lord Justice Newey has just put to you about having regard to interests raises a different point in relation to 4.2. See, in relation to 4.2, the good faith obligation is owed not just to other shareholders, but it's owed to the company as well, isn't it?
Yes.
In the sense it talks about good faith in all dealings with the other shareholders and with the company.
Yes.
Yes, and the undertaking is given to the shareholders and the company. Now, If you have a situation where the interests of the company require removal, commercial interests of the company require removal of Dr. Sachs, and that is a genuinely held view.
Well, there are two questions, because there's, does it objectively, and whose view is
Okay,
it
well,
is.
let's assume for present purposes that it both is objectively required, but is in any event generally the view of, I don't actually mind whether you either or both.
The view of whom?
Okay, well, let's assume that the investors genuinely believed, brackets rightly or wrongly, that it was in the interests of the company, necessary in the interests of the company to remove Dr. Sachs. How do they balance that requirement to take into account the interests of the company and your good faith argument, which requires them to have regard, quotes, to the interests of Dr. Sachs?
But it doesn't require them to subordinate their interests to.
No, these are the interests of the company as opposed to the interests of Dr. Sachs.
Well, they are capable of being balanced. The duty owed to the companies by the investors is capable of being balanced with their duty to the other shareholders. Because it's only a duty owed in their capacity as a shareholder.
Yes, but if as shareholders they form the view that it is necessary in the interests of the company to preserve its business to remove Dr. Sachs, are you saying that there is some countervailing requirement that they have to also, quote, take into account Dr. Sachs's interests, which are diametrically opposed? How does your interpretation of this provision cope with that situation?
That they're not inconsistent. That they are that looking at it from the point of view of the investors, they can owe duties of good faith to the other shareholders and the company, and in respect of the removal of Dr. Sachs, for example, they are not inconsistent. The duty to have regard to the interests of the minority shareholders is consistent with their duty of good faith to the company. Their duty of good faith to the other shareholders is not defeated by any paramount duty to the company. They're not fiduciaries, the investors. And these are simply two duties of good faith owed at the same time.
But on your analysis as to the content of the duty of good faith, so duty as a result of clause 4.2 to act in good faith by means of taking into account or having regard to the interests of other shareholders, here Sachs and Faulkner, but also as part of its duty of good faith towards the company to take into account the interests of the company.
Yes.
And have regard to those interests. And if they are conflicting, what is the shareholder to do? What is the investor to do? They coexist, but they conflict.
But they can't. Because of the nature of the duty, they can't conflict. Because
so if it's in the interests of the company to change the constitution, it is also in the interests of shareholders.
No, my lady, because they ask themselves with one hat, what's my duty to the company? Mm-hmm. So I have regard to that, which says Dr. Sachs has got to go. I then turn to the minorities and say, what is in the interest of the minorities?
Why do you say just turn to the other minorities, by the way?
Well, because that's the duty of good faith.
To the other shareholders.
To the other shareholders.
That includes the other, quotes, majority shareholders.
Yes. And they say that duty of good faith leads to another conclusion. Mm-hmm. They then have to make up their minds.
Right.
They're not. So the duties aren't conflicting. It's just that the fact that there are both these duties requires a fairly complex mental exercise.
Am I grossly oversimplifying it if I say that really you're saying they're process duties? They're duties
Yes.
to take into account things. Having taken them into account, you can decide anything you like, but you have to take account of things.
But you express it far more elegantly.
I don't think that was very elegant.
I was getting there, but
But the consequence of that is that it's not a breach of clause 4.2 duty of good faith for an investor to say, I form the view, brackets, genuinely on rational grounds, I honestly believe that the interests of the company require removal of Dr. Sachs. You then have this process of turning your mind mentally to the interests of Dr. Sachs, which presumably require a different perspective. But having weighed the balance, the investor says, the shareholder says, no, I form the view that the interests of the company, and indeed my duties to shareholders generally, require Dr. Sachs to go. That's not a breach of 4.2 to Dr. Sachs,
no,
or indeed anybody else.
But this argument is posited on the assumption that you're with us, that the duty of good faith does include a duty to take into account the interests of the minorities.
Yeah, well, that's why I'm putting it to you. If I was against you on the point, I wouldn't be bothering the question.
No, but then in which
At least
case...
I haven't formed a view. I'm testing the proposition on the footing you're right, because I want to see where your argument goes. That's what I'm doing here.
Well, I'm afraid, see the problem.
Okay.
Yeah.
I mean, in a typical case, you'd think that once you decided that for the company to survive, leave aside insolvency, but to survive as a real business, Dr. Sachs had to go because otherwise you weren't going to put in the money that was going to keep it going. Actually, that would be in the interests of the minorities as well as the company, because without a company there would be nothing for the minorities to share in.
Yes, but they would also have the interest in the fact that Dr. Sachs, that wouldn't be their only interest. Their only interest, as found by the judge, included, in our respectful submission, rightly, the fact that the removal of Dr. Sachs was a seismic event, and that he was the jockey they were backing. So the interests of the minorities did not only include the general interests of the company in continuing to trade. They included the reliance upon Dr. Sachs as the jockey they were backing.
What blind reliance, irrespective of whether the jockey is running the horse into the fence, not over it.
No, I wouldn't submit that it was. But if there might be...
Having made that concession about what would, and having weighed the balance, forming the view Dr. Sachs had to go, that would not be a breach of clause 4.2. Where does that leave any position by reference to fidelity to the bargain, as you allege it to be? That the bargain was not an absolute bar on removal of Dr. Sachs.
No, but I if I recall my submission, my lady, and I apologise if I'm missing my lady's point, but I accepted that the judge may have gone too far, but he was, at the very least, his findings should stand on the basis that the duty of good faith did require consultation and regard to the interests of the minorities over a replacement.
Yes.
I'm
sorry if I'm missing the point, because
I'll carry on thinking.
I may have missed the point in my
And
Justice Snowden.
to jump to the end, you say that, so to speak, is sufficiently unfair and sufficiently prejudicial to justify them being bought out.
Yes. But it's my own friend, for good forensic reasons, concentrated his fire, or most of his fire, on the removal of Dr. Sachs. That it's not just the removal of Dr. Sachs that happened here. It's everything that happened, in particular, between the removal of Dr. Sachs and the removal of Mr. Faulkner. So we're not relying on removal there, because during that period, Mr. Faulkner is, as I said, the chairman of CPGL and CP UK, and he was effectively excluded because the investors had decided to ignore the Constitution and to run the company themselves. So,
when you say for themselves, they decided to run the company themselves.
Themselves.
Doesn't necessarily mean the same as for themselves.
No, themselves. Yes,
Yeah.
yes. And that must, in my respectful submission, have been, at the very least, a breach of Table A, Article 70, as supported by the other provisions that I've taken you to just now. But it's more than that, because they did that because they regarded the Constitution as obsolete. So they no longer intended to allow the company to be managed in accordance with its Constitution, in other words, by its board, regardless of the finer meaning of the Constitution, regardless of the good faith clause. And that, in my respectful submission, must have been, well, not only a breach of the good faith clause, if you're with me on its general purpose being the keeping the investors out of control, stopping the investors controlling the board. But in any event, the provisions of clause 5.2 and 5.3, could I briefly take you to them?
And we've been asking you lots of questions, Mr. Hollington. Can I just check that you're vaguely able to follow the course you were taking, and we'll get to the end of your submissions?
Yes, I will definitely finish by, I think I got till 2:30.
Yeah, absolutely.
Yeah,
So
no, I will.
we're not causing you to get into difficulties.
I'm grateful because it gives me the opportunity of expressing what lies at the heart of our case,
Yes,
rather than it getting lost in formal submissions.
yes. So 5.2 and 5.3.
Yes, go back to Core 2, tab 20, page 544. Could I just say that I'll obviously think over the long adjournment about points that have been made, and insofar as I've missed the point, I will certainly try to meet it tomorrow.
Yes.
5.2. You've been taken to the business is conducted in accordance with good business practice and on sound commercial and profit-making principles. Now, the judge did not interpret that so in the way that Milona Friend, I think, for the first time was ever submitted, but I may be corrected on that. That because it's the conduct of the business, that doesn't include the management of the company generally. Well, in my respectful submission, that can't be the case. I mean, why would the obligation to conduct the business, conduct in accordance with good business practice, not extend to the way in which the board is constituted in order to conduct that business?
Well, I understand the question, but look what it says. Is that just a mistake, do you say?
Well,
We should infer it's a mistake?
No, but you should interpret that, not restrictively, but as including what happened here, which was that the board was completely bypassed, because the board was managing the business. So if the board is not managing the business is not being conducted in accordance with good business practice. If the business is being managed by the investors, which is what happens here, there's a breach of clause 5.2.
What's the board managing the business? I mean, there were no board meetings for years and years. it looks as though matters have been left really in the hands of Dr. Sachs.
Could I come back to that? Because that's the point I was going to deal with discreetly. But I'll deal with it.
Then. No.
Yes. Yeah. My short answer to it is that yes, it was managed by Dr. Sachs for many years, but the position once he'd been removed was chalk and cheese. Because now, whereas Dr. Sachs was the representative of the minorities in whom they had confidence as the jockey, had been running the business up till then, he's now been removed. Now they've only got Mr. Faulkner to represent them, and he was deliberately excluded. And I'll deal with the points about what difference does it make that he could have called a meeting in due course. But my short answer to that is that given that they'd already decided to withhold information from him, even if he'd called a board meeting, it's ridiculous to suppose that they would have said, it's a fair cop, we've withheld all this information from you, here it all is now.
Just on the interpretation which we were looking at, and my lady's point to you, I mean, where the draftsman wants to refer to business with a capital B being conducted in accordance with good business practice in 5.2, the draftsman uses a capital B. Where the draftsman wants to refer more generally to the conduct of the company's affairs, such as in 5.3a, draftsman uses the expression shall carry on and conduct its business and affairs, small b, in a proper and efficient manner. Why isn't 5.2 obviously limited to the business as defined, namely the production and supply of projection products and technologies?
Well, it is confined to that.
Right. So what's it got to do with events in the boardroom, to put it mildly?
Because the business is not being conducted. The business is not
Business
being
is the production and supply of projection products. That's not what goes on in the boardroom.
No, but it's being controlled. The ultimate body of the company responsible for the conduct of the business is the board.
So when the draftsman uses the expression 5 lines later, conduct its business and affairs, which is a more conventional, I would suggest, way of putting it, affairs certainly, business small b, you're saying actually that means just the same as capital B business.
Well, the answer to that is if it isn't the same, then I rely on 5.3a. So in a sense, this argument about what the last sentence, the last 2 lines of 5.2 is academic, because if I can't rely on 5.2, I can rely on 5.3a for exactly the same purpose.
Right.
So, and as the judge held in paragraph 389 of his judgment, proper means proper corporate governance. It refers to proper corporate governance. And that is not a ground of appeal. That interpretation is not a ground of appeal, and it wasn't criticised in Malone Friends' submissions.
So you'd say it's a breach of 5.3a if, for example, the director asks for something and is lied to, or the thing is concealed from him.
Well, it's more than that. It's the investors.
I was trying to make it. Don't kick the gift horse in the mouth. I was trying to give you the easy one.
Yes,
right?
yes.
That's an easy example of something which you'd say would not be the conduct of business and affairs in a proper and efficient manner. If a director asks for something and somebody lies to him, or the secretary says, we haven't got it, you can't have it.
I'm not used to my lord providing this gift. Yes, I have yes. Right. That certainly is an example of a breach of 5.3a.
So in fact, given the type of thing you're complaining about,
yes,
it's more 5.3a, is it, rather than 5.2?
Yeah. Yes. Right. Now, so far as the
sorry to detain you again. So, I mean, in one sense, the business hadn't been conducted by the board for quite a long time because Dr. Sachs had been conducting it. Yes. But you say what happened after Dr. Sachs' removal is different because it was being conducted with no legitimacy under the corporate structure. The investors had no standing to take over the management.
No, that's the way I put it. And they deliberately excluded Faulkner. They may not have been personally responsible for the lying to Faulkner, but they were responsible for the strategy of ignoring the Constitution, as found by the judge. They were going to run, the investors were going to run this business, and Mr. Faulkner was nothing but an irritation. Can I then move on to Roadmap 1, which is the findings that they had decided upon that strategy?
Are you coming back to look in any more detail at good faith or meaning of 4.2? Have you sort of done?
I'm coming because I want to. I am going to come back there because I'm going to deal with, first of all, what are the elements of good faith.
Yeah, okay, that's fine.
Yeah.
As long as you
Yes.
haven't.
No. So I now deal with the, if you have to hand, the first item under Roadmap 1, my Roadmap 1, which is to take your lordship as quickly because you're well familiar with the judgment, with those parts which we would wish to draw to your attention, which support what we say is the right conclusion, which is, as I set out in the subject matter, the judge found unfair prejudice on the basis of factual findings that by adopting the strategy arrived at over the weekend of the 12th to the 13th of March and implemented thereafter of management by the investors and their nominated directors, without Sachs and Faulkner and with no regard to the interests of the minorities, the investors, with Fletcher as the leader, didn't just act in breach of the provisions of the Constitution. They drove a caution horses, ignored, desired to sweep away, overrode, treated as obviously dead letter, bypassed, marginalised, without the Constitution. The judge used a number of ways of describing what they did. Can we see what he found? Beginning at paragraph 10 of the judgment, page 93, the principal characters, you'll see 10 to 12 who Mr. Fletcher was. And he gave evidence, and he was really the key investor nominated director, and he had his own interests in Q. 86, paragraph 86. You will see what, this is the origin of the judge's comment that Mr. Fletcher had a very low opinion of Mr. Faulkner. I draw your attention to paragraph 86. Then the paragraph 142. This is the beginning. 142 to 153 is paragraphs 142 to 153 is the fateful meetings and communications between the parties on the weekend of the 12th to 13th of March 2016, which resulted in the removal of Dr. Sachs on the following Monday. And it followed the tense meetings of the previous week, at which there had been discussions about the appointment of investigating accountants. And you'll see that Mr. Fletcher was there, and representatives, Dr. Abramoff and Dr. Froloff were both there, and Mr. Cochrane, all of which was or from Vollin, and you'll see that late on the Sunday there was a communication with Mr. Tenenbaum, who was a representative of Mr. Abramovich, and you're familiar with what was decided here, but you will see that Mr. Fletcher was very much involved in this strategy meeting. The consequence of it was that a decision was made. You'll see that at 145. The reading of the minutes, consistent with the meeting that Mr. Fletcher sent to Mr. Shanahan, who was his preferred investigating accountant. During the course of the meeting, standing down, he said, reflecting the fact that the Minden representatives had not been consulted, as of now, and it must just conceivably change in the next days, once we inform Abramovich, we've decided to restructure Compound Photonics on our own for now. So they were consciously aware of the fact that it was they who were making the decision, the investors who were making the decision. And you'll see that paragraph 153, one of the proposals was that Mr. Fletcher in the lead, Mr. Fletcher made clear who he thought should take over the management of Dr. Sachs. His proposal was Brian Bolger to re-interim, which is in fact what happened, presumably following discussions and about without any other formality, including any board meeting. Then 162.
You sort of paragraphs 148 and 150. As I read them, are evidence, or are there findings, I'm not sure, that Mr. Faulkner was broadly inclined to agree that that Dr. Sachs had to go, and that the investors were not going to just ride roughshod over him, but actually were keen to get his support. Have I misread those?
No, you haven't. There's an issue as to whether he was told the correct position so far as the funding was concerned. He was also told.
Mr. Faulkner didn't think that he was breaching the shareholders' agreement or the Constitution when he agreed to the Dr. Sachs had to go.
No.
But he complains. He complains about it nonetheless.
He is not the minorities. He's and that is the finding that the judge made, that the investors did not consult with the minorities. It wasn't just, this was such a seismic event that it wasn't good enough just to see what Mr. Faulkner said over the telephone. And in any event...
Sorry, does Mr. Faulkner complain about the removal of Dr. Sachs in the petition?
He does.
He says it's a breach of clause 4.2
by
himself. To the extent he was supportive of it.
Well, he says that... well, he accepts. He did say that he would follow the money. But he was also... He was also led to understand that there would be a board meeting.
Right. He certainly didn't take the view, by the sound of it, consultation or anything else apart, that the constitution of the company in its broader sense prohibited following the money and removing Dr. Sachs.
No. Yeah, but he's just at the end of the telephone in South Africa, being run up by people who've already made up their mind.
That doesn't matter, does it, on this point? As a matter of principle, he saw nothing wrong constitutionally, contractually or otherwise in changing the makeup.
No, my lady, that must follow. Yeah.
I mean, he presumably thought that this was in the interests of all the shareholders.
Yes.
Including the minorities.
Yes. He said he would follow the money. Then, if I may go on, to 162. Just to show the centrality of Mr. Fletcher's role in this. Then how do I go back to 156? And then at the meeting on the 14th of March, if one goes back to 156, you see Mr. Fletcher's there, and sorry, this is a meeting on the Sunday, so I don't know why going back to 156. That must be a mistake in my note. But anyway, Mr. Fletcher's there on the weekend of the 12th and the 13th of March. He's there on the meeting of the 14th of March, which is what I may be intending to refer to. And then moving on to 175. You'll see that he did not. This is the first update meeting on the investors' update meeting or presentation meeting on the 13th of April. You'll see that Mr. Fletcher would have been discouraged from attending, seems to be consistent with Mr. Fletcher's view, more generally of Mr. Faulkner, with the idea that Mr. Fletcher would not have wished Mr. Faulkner to be involved in the investors' deliberations and decision-making. I therefore accept Mr. Faulkner's evidence on this point. And you'll see that he accepted the evidence as to what Fletcher told Faulkner above.
This is a presentation to investors.
Yes.
It's not a company meeting.
Precisely. But they're running the business. That's the point.
Yes, but it's not a breach of the Constitution in any way, shape or form for Mr. Faulkner not to have been invited or to be discouraged from attending.
Well, in my respectful submission, it most certainly was, because the investors' meeting was operating as the board.
Well, that's a different point.
Well, yes,
Okay.
yes. But my point is that the investors were operating as the board, and Mr. Faulkner, for whatever reason, was told he couldn't come.
Well, does the judge describe this meeting of the 13th of April as, in effect, a board meeting?
He does, yes.
So where did he do that?
I'll come on to it. Well, he says the investor update meetings bypass the board. I will come on to it. I just don't have it at my fingertips.
Okay.
That reference. 178. Mr. Faulkner was developing concerns about what he had been told. And in May, he wrote to Mr. Fletcher to propose a board meeting and proposing that Dr. Lynch should also attend. In a telling response, Mr. Fletcher was lukewarm about the idea, although frank enough about the reasons why. And then you will see, if you would read that, particularly the last half of what's in italics. Then 181 said he should resign. Going over the page. Governance needs to be brought in line with the ownership structure. And then 182 is important. Then, just as part of the narrative, 184, the paragraph 184, headed Mr. Faulkner's light bulb moment. He suddenly realised that things were going on behind his back. That's his evidence in cross-examination. You see at the bottom of page 125, you see I'm excluded from the details. I'm scrambling around, picking up tidbits and trying to piece things together. I am the sole director, that is of CPUK, which owned Newton Aycliffe. And then I accept Mr. Faulkner's evidence on this point. And then you'll see the way in which the judge summarises it further in 186. And just for the sake of completeness, I forgot to take you to 183, which was the investor update meeting, again to show that Mr. Faulkner was not invited and did not attend.
Was Mr. Faulkner? Mr. Faulkner wasn't ever an executive director, was he?
Well, he was paid by the company. He until Dr. Sachs's removal, he was
No,
not.
I meant a director with executive authority to. I mean, who were the executive directors? By executive, I mean people with authority to commit the company to contracts, serve notices, and things like that.
So far as CPGL was concerned, and I suppose that's the only company that really matters.
Yeah.
He was not an executive director of that.
So he'd never had authority to. So who did take executive decisions? I commit the company to contracts, serve notices, and do things. Was it Dr. Sachs?
Well, until Sachs's removal, Dr. Sachs. Thereafter,
right,
it would probably be Mr. Bolger, but he wasn't on the board.
Right. So when Dr. Sachs did things on behalf of the company, important things. I mean, he didn't convene board meetings.
No.
He just did them.
No. Yeah.
And then when he was removed, Mr. Bolger assumed the role of executive director and did things.
Well, we said he did, but the judge said that he wasn't a de facto director. He wasn't a de jure director. If your lordship would just bear with me.
Yeah.
No, but after. Well, we submit that it was in practice Mr. Bolger, even though he wasn't a de facto director. That the de jure directors were members of Q. So Mr. Fletcher would have been the main man at Q, but he wasn't, as we understand it, an executive director. The only executive, or the most senior executive was Mr. Bolger, who wasn't a de jure director.
I mean, just looking at the board of CPGL, I then had Mr. Faulkner, Mr. Fletcher, Mr. Lind, Mr. de Court, and Mr. Berkey.
Mr. de Court definitely wasn't. He was a lawyer in Liechtenstein somewhere. Mr. Berkey and Mr. Fletcher were both Q, who were more financial advisors. They would have been the most senior directors. So if Mr. Bolger wasn't a director, and so can't be regarded as the person on the board with the executive authority, it must have been Fletcher and Berkey, who would have attended the investor update meetings, because the investor update meetings were a presentation by Q to the investors. And then there's a long summary of the facts, which I don't think it would be necessary to take you through, relating to what was going on particularly with regard to Newton Aycliffe and the involvement of Cayenne. because I think all that would be necessary is to take you to the summary that the judge makes of that. So if I can jump on to 253. So this is the summary. This is the judge really setting out the facts. He's not setting out his conclusions. We'll come on to that in due course. This is a letter or an email of the 19th of August, where he makes the point, as you can see, he makes the point that he's the chairman of CPGL, sole director of CPG. He's taken legal advice, and he's complaining about the lack of information. Then at 267, on the 9th of September, is Mr. Fletcher, so again the central role of Mr. Fletcher, offered the CEO role to Mr. Wu. Mr. Faulkner, of course, was not involved in any relevant decision to do so, although he was still director and chairman of CPGL. And then I draw your attention to the letter from Gordon Dadds, or the extract from it, on the 9th of September, and you'll see what is a fair summary of our case. And then at 269, you'll see at 268, so this is there was an intended meeting to remove Mr. Faulkner on the 18th of October, which was ineffective. And just if you would note what Mr. Faulkner said in his letter objecting to his removal, particularly the second paragraph, which in our respectful submission reflects the agreed common purpose of the agreement of the Constitution. Then at 273...
So at 269, this is Mr. Faulkner saying, if the resolution is passed, that's what, the resolution to remove him?
Yes.
There will be no counterbalance, no independent voice on the board, wholly contrary to the spirit and intent of the... So he doesn't say, and there's an obligation upon you to find a replacement for me. In fact, he's arguing the contrary.
Well, that on the contrary, my respectful submission is implicit in that. But if his removal would result in no independent, then why aren't you offering to replace him? And obviously they weren't offering to replace him.
Yeah, but he isn't saying, don't think it's going to end, even if you get rid of me, you have an obligation to appoint somebody else in my stead to represent the...
He doesn't actually say that, no.
And he hasn't said that after Dr. Sachs resigned.
Well, he didn't say that after Dr. Sachs resigned, no. But in my respectful submission, he's implicitly making that point. Because otherwise, why would he say, if you remove, there will be no counterbalance and no independent voice? It'll be wholly contrary to spirit and intent of the 2013 shareholders agreement.
Did the judge find that there had to be that the agreement required appointment of a replacement?
In our submission, he did, yes.
How do you explain paragraph 417 then? Because one one of the issues that the judge mentions when he says there was no consultation was that he says, aside from other matters, the minorities may have had views about any successor appointment and about whether any successor to Dr. Sachs should similarly be accorded special status and voting rights. I mean, he seems to think it's all up for grabs. I mean, if the agreement requires it, I mean, why is the judge saying that?
Well, I put it no higher than that. The minority, well, and this is in my respectful submission what he found, that there was a duty to consult with the minorities.
Yeah, but I thought I understood your case to be, first of all, they couldn't be removed. We've discussed that. But if they were removed, they had to be replaced to preserve the balance, the constitutional balance. But nobody seems to have made that point.
Well, even if the judge finds, aside from other matters, they may have had views about any successor appointment and whether any successor to Dr. Sachs should similarly be accorded special status and voting rights on CPGL's point. So that is a duty to consult.
Yeah, but Dr. Sachs doesn't say, as I understand it, all right, I'll step down. Here's my replacement, or I suggest we've got to have a replacement for me.
Yes.
It doesn't say that.
No,
Mr. Faulkner says, I don't want to be removed because if I'm removed, there'll be a gap. He doesn't say, and you've got to appoint, and there has to be a replacement for me to maintain this balance, to represent the minorities. And when the judge, there may be other places, but in that paragraph, when the judge is looking at what's to happen, he doesn't say it's just a question of who. He seems to think it's all up for grabs just to be negotiated.
Well, he probably, whether this was investigated or not, I don't think it was in evidence. He may well have taken the view that if they were going to remove him, they were never going to appoint anybody else, because why would they remove him then?
Well, because they thought he was a pain in the neck.
Well, that isn't a good enough. Well, no, that is.
But to find somebody who isn't a pain in the neck.
Well, in my respectful submission, that would have been unrealistic. It would have been perfectly realistic for Mr. Faulkner to take the view that if they were removing him, and they certainly, he would certainly have taken the view that they had no reason to remove him. If they were, so far as he was concerned, if they were going to remove him, they certainly weren't going to consider appointing anybody else.
What sort of person could have been appointed? I mean, I quite follow that Dr. Sachs had a crucial role. He had been the jockey, but he's gone. So we're now supposing a situation where Dr. Sachs has gone, and indeed Mr. Faulkner. And you say, well, there is an obligation to appoint a replacement. What sort of replacement would it have been?
Well, it could have been any non-executive director with the appropriate experience.
Which would be
anybody independent who and certainly my understanding there's a big market for independent non-executive directors who will take posts in a company such as this. They might have financial experience, or they might have business experience, or they might have technical experience. Well, most likely to be technical experience, but either financial or business experience. It was perfectly possible. And that, in my respectful submission, was something that was a possibility which the investors had closed their mind to because they regarded the Constitution as a dead letter and wanted to run the company on their own.
But did your side, your client's side, say that you can't just disregard this Constitution from 2013, even if you can remove us for reasons that you think are genuine in the interest of the business, we're entitled as shareholders, minority shareholders, to have representatives on the board. here are 2 or 3 or 4 suggested names. Are they acceptable to you?
We didn't make that. We didn't come up with any particular names. No, because for again, in my respectful submission, it was obvious what the reaction to it would have been. It would have been a waste of time. The investors had decided
Sorry,
that.
you're answering a lot of questions, but be careful if I may say so. What you say? Are you saying that there was an actual thought process, saying we're not going to put forward any independent options because we know of the reaction, or is it more accurate to say it wasn't addressed?
It wasn't addressed.
That's fair.
Yes,
Thank you
yes,
very much.
yes.
Thank you.
It's the fact that they didn't put forward the idea of alternative appointments is perfectly consistent with what the judge found, which is that the investors had decided to run it on their own and would not have been interested in the appointment of any independent directors. So the fact that they didn't.
Sorry, and you said 2 things there, pick up my lady's point, that the investors had decided to run it on their own. I understand the judge, you say, found that. Did he find the second bit of your sentence?
I can't remember what it was now.
Would not have been interested.
Did he find that, as a fact, that the investors, if they had been asked, would not have been interested in any other?
No, they didn't. He didn't make that specific finding. But he did make the specific finding that they did not consider 417, whether they were under a duty to inform the minorities and actively consult with the minorities before any final decision was made. But this isn't the only place where he makes similar comments.
Okay.
So going back to, I think I'd just taken you to 253. Yes. Then the next is 267, which I think I had taken you to, so I'm sorry to go over that again. 269, I've gone to 273. 273, I mean, this is not, this is an important, actually, feature of the evidence, which I think is relevant to the point that my Lord Justice Snowden put to me. And I'd invite you to read it for yourself. This is after the meeting on the 25th of October. That is a strong indication that the investors were disregarding the interests of the minorities and would not have been at all receptive to any consultation with them over the appointment of replacements.
Well, it's a slightly different issue here, isn't it? It's about whether or not they'd be interested in a deal whereby the minorities acquire Newton Aycliffe.
Yes, but it's a general. I mean, that is the way that Mr. Fletcher dealt with any offer of compromise. And then we get on to the analysis. So there's a long sequence of setting out the evidence, and then if one comes to 336, I take you to this because although it's our case, it's a case that the judge accepted. And I draw it to your attention. I think you've already been to this, but I draw it to your attention because it's sort of related to the usurpation by the board. But you'll see how I put the cases to particular agreed common purposes. It's not just entrenchment, but the prevention of foreign and member from obtaining control. And then my argument was that both these purposes had been overridden or frustrated by the actions.
Just thinking about that. You say that's a distinct purpose. So we suppose that Dr. Sachs and Mr. Faulkner have gone.
Yeah.
And we suppose, as you've been explaining the case, that somebody else has been appointed at the behest of the minorities, I suppose. I mean, the investors would still have had control.
Well, two answers to that. First of all, would clause 7.13 still have applied? So if the replacement had been, we would say that any replacement would have stepped into the shoes of Faulkner with a veto right. But even if we're wrong on that, at least the minorities would have had a representative on the board.
So I would have had a
representative on the board.
But you didn't test out that proposition at the time.
Well, it was unrealistic. They were never going to, in my submission, the reality of the matter was that they were never going to admit of an independent director, particularly if he or she had to be paid. So that's our case. Then just jumping forward, just for your note, it's accepted at paragraph 391. I've already taken you through the factual matrix and then he goes on to explain what that means in the following paragraphs. But for this purpose, I don't think I need to dwell on that. Then at 375,
The submissions that the judge accepts at 391, is the absolutionist view that you are recorded as advancing at 336, 346. Just can't be done.
yes. Although it was clear, and in my submission it's clear from the rest of the judgment, that both I and the judge allowed for removal for misconduct.
Putting aside removal for misconduct, which was common ground,
Yes.
I put this to Mr. Gledhill. The judge was faced with one side saying, can't do it at all,
Yes.
ever. The other side saying, we can do it at will.
Yes. Yes. That is, and in our submission, it's a matter for this court to decide who's right.
Or whether neither
Or neither are right, it's somewhere in the middle. Yeah. That's why I said it's difficult to allow for all contingencies in our submissions. So 336, and then 375, I think, was the next one I was going to go on to on this topic of usurpation. This is just the judge's correct analysis of the duty of Section 172 duty as being a subjective duty. That just ties up with. We then goes on to 390, where we've already been there before, and then 393. That was the content. Been there before, and then 416. We've been here before, 416, 417, in particular 417, where the judge finds a duty to consult. Although the judge doesn't set out my submissions below that there was a duty to consult, those were my submissions, and he does find a duty to consult. I can give you tomorrow morning. I can give you the references where that was part of our case. What there was, in any event, a duty to consult, and you can see the way in which we put it.
This whole section 413 through to 417 is actually dealing with taking interests of minorities into account.
Yes.
It's not actually to do with consultation, is it?
It's in, yes. Well, if you're with us on the duty of good faith, including a duty to take interest into account, then we don't, I think, need to establish a duty to consult. It's if you're going to have regard, if you're going to have regard to the interest of the minorities properly, that entails a duty to consult with them.
I don't know about that. To take a completely different area, there's the public sector equality duty requiring you to think about various things as you make decisions. But that doesn't mean you have to consult people necessarily.
No, and the context is all. In this context, in my respectful submission, having regard to the very unusual features of this relationship and the terms of the Constitution, a duty to take into account the interest does include a duty to consult.
When you say take into account the interests, is it the interests of the shareholders as a body? Is it to take into account the interests of the other shareholders, which is, I think, what clause 4.2 says? Or is it to take into account the particular interests of the minorities as defined in the petition for who you represent?
It's a duty to take it. Well, the first point is it flows from the duty of good faith. So
yeah, this is all about what does the duty of good faith imply, and so I'm asking.
Given that the purpose of the presence of Sachs and Faulkner on the board was A, to be the jockey, and B, to be the representative of the minorities, it follows in our respectful submission that although one can't treat the minorities as a class, and there's no need to, there was a general duty to consult in whatever way
so what you've got to
suited the circumstances.
Straw poll?
Sorry?
Straw poll?
Well,
sort of call them up?
The
email out?
Well, the first point of call would be to consult with Mr. Faulkner. Properly to consult with Mr. Faulkner and to say and then he would be the one who would know how best to consult with the minorities, because he was the one who'd introduced them into the investment. So in my submission, the manner of consultation would be a matter that turned on the circumstances at the time, and it wouldn't have been an insuperable hurdle.
And you say it's, and so just the minorities, or the minorities and the other, quotes, members of the majority?
Well, anybody other than the Russians.
Why wouldn't one Russian investor, when complying with 4.2, have to take into account the interests of the other Russian investors? Why do you treat them all as if they're just one unitary being?
Well, there's no point consulting with the Russians, because it's the Russians who've made the decision.
No, I'm just looking at what 4.2 requires.
Right.
I mean, does 4.2 require each shareholder to consult with some or all of the other shareholders? And if so, how do you make that distinction on the basis of the wording of 4.2?
Well, it's a detail, in my respectful submission, that would be the detail of the manner of communication would be a detail to be addressed on the particular occasion. There wouldn't be any way in which the consultation had to take place It would take place in whatever way suited the circumstances.
And the interest that you have to take into account, putting aside consultation now, the question of taking in account of interests, is it of all the other shareholders, the shareholders as a body, just the minority, some of the minority, or what?
No, just the shareholders other than the Russians. So the body is everybody other than the Russians, so who are Vollin Mindens. You look at the share register, it's not Vollin and it's not Minden. Anybody else is the minority. So you could have...
So when the agreement is entered into, somebody taps Mr. Abramovich, say, on the shoulder and says, see that 4.2, it requires you to take into account the interests when you are doing something. The interests you have to take into account are just the minorities, but you aren't allowed to take into account the interests of the other two Russians.
No. This is the duty is only to have regard to. Let's go back to this process point. It's not a fiduciary duty. So
no, I'm just trying to understand this duty, which you say is implicit in the concept of good faith, which is to take into account other people's interests, yes, which the judge says requires the taking into account of the interests of the petitioners as well as their own interests. He treats the investors as a conglomerate, and he treats the petitioners as a conglomerate. And I'm just trying to explore whether that's actually what clause 4.2 can mean.
Well, insofar as if one is asking how does the duty of good faith operate in particular circumstances, so it's a soft provision. It all turns on the context in which it applies. It's not a black and white provision. It all turns on the circumstances in which it arises. The circumstances in which it arises in this case is the investors have made a decision. They're under duty by virtue of the duty of good faith to consult. Therefore, they consult with every shareholder other than themselves. One way of doing it would be to hold to convene a general meeting at which the minority shareholders were able to express whatever views they sought to express. I mean, whether it was necessary to do that in the particular circumstances of the case would depend upon the nature of the decision. But certainly, so far as the removal of Mr. Faulkner was concerned, so their last remaining representative, in our submission, it required something pretty formal. Anyway, we haven't reached the then 429. Well, there's well, we've been over that. I don't propose at this juncture to go through that again. Then 431. So here we now finally reach the analysis, and here we begin to see the conclusions on his findings of in the period after, and there you can read it, in the period after Dr. Sachs, if you would. The board as such was therefore effectively usurped by the majority shareholders. And you'll see that Mr. Fletcher accepted that in cross-examination. And then this is, sorry, that's obviously my case, and it's accepted as you'll see further on. And then as part of my case is 435. Just to note, if you would read 435, what little...
Sorry, I have lost the previous reference you were taking us to.
I did go to 434.
So that's part of the petitioner's essential
Sorry,
point.
that's-
So
yes,
as you
yes.
say, that's
Sorry,
your
I'm
case.
sorry.
Yes, that's our case.
Sorry, yes.
Yes. I think I may have initially led you to believe that it was a final.
Sorry, yeah, no,
Yeah.
sorry.
And then we get the particulars in
The
435.
particulars 1 to
Yeah.
3, which are quite important
Sorry.
because it summarises, first of all, what Mr. Faulkner wasn't told, and it also refers to where he was positively misled. I mean, the precise detail of what Mr. Faulkner wasn't told.
But he's still at 435, isn't he? Still outlining what your case is.
Yes.
Yes.
Yeah, he's still a director.
No,
No,
he's
no.
outlining your case still.
I beg your lordship. Sorry.
So my lady's putting it.
Yes, no, this is still reciting your case.
We're reciting our case.
Yes,
yes,
yes, yes.
but he accepts it later. That's why it's important to notice.
He doesn't accept it later. He says at 440, he puts it all together and say, I'm going to treat this all as a complaint about lack of any real involvement.
Yes, but he does. In my submission, yes. He says 456. Pausing there, it seems to me the matter complaint identified in 435, 1, 2, and 3 above are all best characterised as examples of greater or lesser severity of this more general problem of CPGL's constitutional machinery having broken down.
So the short point is he doesn't find individual breaches of duty. It may not matter, but I think that's what's...
He doesn't find them as individual breaches of
Correct.
duty, but he finds them as fact, which are symptoms of a wider breach of duty.
With respect, he doesn't even find them as fact. And this is the point I made to your lordships earlier today. From 455 to 458, he discounts all of those allegations of failure to inform bar 1. And that is the one at paragraph 459. So all of these allegations of non-disclosure are in fact rejected.
I don't accept that.
Oh,
Well,
that's what it says.
well, he will deal with it in reply. And then you'll see if you read from 456 onwards, he is accepting our case, but saying it doesn't form a freestanding breach of duty. It's symptomatic of the wider breakdown of the constitutional framework. So if you read from 456 through to 461,
Well, okay, before we get to 448, he says, it follows, I do not accept the petitioner's generalised complaints about a lack of information. But much more significant is the fact that Mr. Faulkner was given no active role in the management of the business, although that is what the 2000 Constitution required. Where in the 2000 Constitution does it require Mr. Faulkner to be given a, quote, active role in the management of the business, as opposed to being a director with the opportunity to participate in board meetings, which Dr. Sachs didn't hold?
in my submission, he's not suggesting that Mr. Faulkner was an executive director, but he was chairman and a director, and the sole director of CP UK, which was the company whose assets was being dealt with. And that may not be an executive role, but it is an active role. A non-executive director's role is an active role. I was certainly going to take you to, before we went on, due to my friend's interruption, to intervention, I was going to take you to 442, which is an important finding. Well, can can we start, because this is important. I think my Lord Justice Snowden had started at 440. It's not so much about failure as about a lack of any real involvement at all in the management of CPGL. Then you see 441, how it originates at the strategy meeting on the weekend of the 12th to the 13th of March. And then 442 is an important finding in my submission. And then 443. Then 448 we rely upon. And then 449 is the evidence of Mr. Faulkner, Mr. Fletcher. And my Lord Justice Snowden asked me for the reference to the bypassing the board. We'll see that at 449. Four, 5, 1. And I would invite you to read from 451 all the way to 461, because these are the findings.
To read now or to read?
Yes, after after we've written for today.
Yes.
Then 468. Just to make the point that it all originated from the Vollin meeting on the 12th of March. Four, 7, 7.
As we're looking at 477, was the judge wrong to treat the shareholders' agreement as part of the Constitution for Section 171 purposes?
We would submit he was right because of the provisions which I'll take you to tomorrow. Section 257 of the Companies Act, 1985, 2006.
Sorry, give me the section again.
275.
257. Is it 257? Yeah, I'm told it should be now in tab 86.
Oh, is it?
But I don't know whether your bundles have been made up. So that would be right at the end of the supplemental authorities, isn't it? To mine? No. So we submit. If you have it.
Yes. I don't know if Lady Justice Carr does.
I'm just looking up online.
Ah.
Carry on, I'll catch up.
It says references in this part, so that's the part to do with directors' duties, to a company's constitution include A, any resolution or other decision come to in accordance with the constitution, we don't say it's that, and B, any decision by the members of the company that is treated by virtue of any enactment or rule of law as equivalent to a decision by the company. So that's the geomatic principle. And we say that a shareholders' agreement to which all, we submit that a shareholders' agreement to which all shareholders are a party and which purports to bind the company because the company is a party to the shareholders' agreement is a decision by the members of the company equivalent to a decision of the company.
So, treated by virtue of any enactment or rule of law as equivalent to a decision by the company.
In our submission, that's a reference to the geomatic principle.
Meaning the rule of law.
Being the rule of law.
So, treated as equivalent to a decision by the company.
Geomatic just says that the company is bound in a matter inter vires by the unanimous agreement of the corporators, subject to some limitations. It's not a decision by the company. It's not equivalent of a decision by the company. It's just that the company is bound by it, surely.
Well, in our submission, whatever the way in which the section refers to the geometric principle, that is the principle that it's referring to.
Can we just? I could sort of see if you had a if you had a document that bit solely on what the company was to do, then that might look like a decision by the company. Here you have a document that says what shareholders are to do. Can that be part of the company's constitution? Is it a decision by the company?
In us, it's a decision which goes to the heart of the constitution of the company, the way in which the board operates.
That sounds a bit circular. I mean, if it's a decision that goes to the heart of the constitution, then doubtless it's constitutional. But is the shareholders' agreement treated as a decision by the company? It feels like something that's treated as an agreement between the shareholders and the company as well. And I mean, I follow that this is additional to section 17 and therefore section 29. You're not suggesting, well, obviously you're not suggesting because you're relying on section 257 that you're within section 29. And indeed, if you were, you'd then have to register the shareholders agreement.
I don't think the argument goes that we're within 29.
No.
It's because 29 deals with the meaning of the Constitution generally. 257, as I understand it, is dealing with the question of what is the meaning of the Constitution in the context of directors' duties.
Yes.
So it's independent of section 29. We don't say we come within section 29. I think we would be in difficulty. But we do say that although it's a slightly odd way of phrasing it, a shareholders' agreement which binds the company and is entered into by all the shareholders is a decision. It's a decision by the company to be bound by the terms thereof.
So the bit that's constitutional is the company's commitment.
Yes. Well, that's
not the shareholders.
Well, that is the company's commitment, which is not only by virtue of the fact that, but it is the company's commitment because the shareholders' agreement expressly purports to bind the company.
So we have to look for where the company has decided something.
Yes, and the company has decided to be bound by the terms of the shareholders' agreement.
So which bit of the shareholders' agreement is relevant to paragraph 477? Where did the company decide that something should happen and the directors then ignored it?
Well, it's both the shareholders' agreement and the articles together. Or if the shareholders' agreement doesn't form part of it, the articles on their own.
So which bit of the articles did the directors reach?
Well, it's 7.13 is the principal one. And Table A, Regulation 70.
when you say they acted in breach of 713, where does the judge consider the question of breach of clause 7.13?
Not discreetly, but he phrases it as in general terms. The Constitution has collapsed. They've sidestepped it. They've bypassed it. They've treated it as
I know
a
it
dead
does.
letter.
It says lots of things in general terms, but sorry, it says lots of things in general terms. You're placing a lot of reliance on clause 7.13
In the shareholders agreement.
in the shareholders agreement.
But there's this, it's exactly the same term in Article. So for this
17.
purpose, it doesn't matter because it's
So where does the judge deal with?
17.9.
Where does the judge say in terms that there was a breach of that provision, whether in the articles or in the shareholders agreement?
Not specifically. He says he finds that they've decided to ignore the Constitution. Now, the most important provision from the investor's point of view in the Constitution were two things. First of all, that the business had to be managed by the board, and secondly, that Sachs and Faulkner had a right of veto over any decisions of the board.
But were those specific allegations that were made and gone into and the judge made findings on? I sort of got the impression that he hadn't focused on clause 7.13 other than in passing as in support of the article clause 4.2 meaning. But I didn't get the impression, and I may just have missed it, help me, that there was any focus specifically on a freestanding breach of clause 713 or the equivalent article.
But it wouldn't have been a breach of 713 in my submission. It would have been a breach of Regulation 70 of Table A.
Well, okay, where does he deal with the breach of Regulation 70? Regulation 70?
He doesn't specifically deal with it because he doesn't need to. He is finding that regardless of the specific provisions of the Constitution, in fact, one can say all the provisions of the Constitution, whatever they are, they had to decided to ignore them.
I mean, I think that works better with the investors and the directors. Can we just go back a bit? Paragraph 428. This is dealing with the removal of Dr. Sachs. He says that in participating in the events which led to the removal of Dr. Sachs, Mr. Fletcher and Mr. Berkey were in breach of section 171A, which is a duty to act in accordance with the company's constitution.
Yes.
Now, Dr. Sachs resigned. There was no exercise of power by the board. So what is it that involved Mr. Fletcher and Mr. Berkey acting in breach of the constitution?
Managing the company by themselves. And
Well, they're not doing that at this stage, are they? It said that they played a part. They were present at the meeting and supported the approach.
Oh, so
And then Dr. Sachs resigns. So where is the breach of section 171?
yes, I'm sorry. I've been addressing a different point, not my law's point. You're not looking at the breach by the investors. You're looking at breach by the directors.
Well, section 171 is directors.
Yes. Which I think my Lord Justice Snowden was also getting at. So I apologise. I missed the point. The breach by the directors is that they were in participating in the actions of removing Dr. Sachs, for example. They were knowingly giving their support to an action which had been reached in breach of the Constitution. Because it had been reached
Well, it hadn't actually, had it? I mean, Whereas the Constitution in this context, how is the Constitution breached relevantly so far as Dr. Sachs's removal is concerned? Because it said, well, they were present at a meeting and supported the approach of removing Dr. Sachs. Well, that's not a breach of the Constitution, is it?
Well, they are the removal of Dr. Sachs is a breach by the investors of the Constitution. So that's the first.
I'm quite
necessary.
I follow the arguments in relation
Yes.
to investors, specifically in relation to Section 171. How does it work in relation to the directors?
Well, they've participated in it. In fact, Mr. Fletcher had led that action, knowingly.
Okay, so he thought it was a good idea. He delivered the decision, specifically which provision of the Constitution was breached by him.
No, he didn't breach the.
Oh, sorry,
he didn't breach the Constitution. I accept that. He didn't breach the Constitution because he as a director, he's not a party to the. He's not a party to the shareholders agreement. But he is a director of a company whose articles provide that its business should be managed by the board.
Yeah, but at this stage, but that's not really relevant, is it? Because we're not dealing with what follows after Dr. Sachs' removal. We're dealing with whether he should be removed.
But the decision was made by the investors so far as the removal of Dr. Sachs is concerned. I don't think I can put it.
No, okay. And then I'm not sure it's worth spending time on this, but 477 is the later stage.
Yes. If I'd reached 477, yes. I suppose I've reached that where nominees were in breach of their periods after, because the balance of power, right, you can read it. And that, for the same reasons, in my respectful submission, was correct. Mr. Fletcher, as I say, was the leader, the leader and the implementer of this strategy. 504.
Still not sure I understand. I'm sorry. Even in 277, what are you saying? Which specifically, which parts of the Constitution were being breached in the way that it was done? The judge talks about the balance of power enshrined in the Constitution had been overridden, by which I understood that to mean that he's talking about when after Dr. Sachs had gone, yes?
Yes, this is the period between.
So
Sachs removal.
Dr. Sachs resigns after being given an ultimatum. He's not replaced.
No.
Now the continuing directors, the Vollin and Minden nominees, as described, what provisions of the Constitution are they breaching thereafter?
Well, the provisions of the Constitution are being breached by virtue of the fact that the board is in effect the investor update, and by participating in.
Sorry, you need to be specific.
Yes.
Are you saying? No, I don't understand which bits you were saying are being breached.
Well, the judge has found that the board, the role of the board was in effect being carried out by the investor updates from which Mr. Faulkner was excluded. For the management of the company to be conducted by a majority of investors and not the board is, in my submission, plainly a breach of the Constitution.
That's not what he says in 477. He doesn't refer at all to investor meetings or anything. He's talking.
But he's
He
referring
talks about the balance of powers being overridden. I mean, can you? Okay, so what? Show me the paragraphs that he must be implicitly referring to. Is it 448?
Yes, or 449. Yeah, 449.
Okay.
And there's one paragraph which I may have passed over, which is of potential relevance, is 454.
So it's really a mission by the directors, is it? It's the directors are not exercising their powers in accordance with the company's constitution. Is that right?
Well, no, it's let's take Fletcher, Mr. Fletcher. He's at these investor update meetings. He is treating the Constitution as a dead letter. He knows that the business of the company is being managed, not by the board, but by a meeting at which a meeting of the investors at which he is present and in which he is making a presentation to the investors. That, in my respectful submission, is a breach of the Constitution, because the business of the company is supposed to be managed by the board. And if Mr. Fletcher is at a meeting which is not the board, which he knows is not the board, and which he is instrumental in ensuring is not the board because it excludes the chairman and a director, he is, in my respectful submission, participating.
But this is not what the judge says, because if you read down to 451, he says it's impossible to be clear about the precise dynamics in the meetings between the shareholders and the directors. The only people who were present post Dr. Sachs's departure were the directors appointed by Vollin and Minden. Even if it's correct that at the investor update meetings the Vollin and Minden nominee directors decided in which direction to go, the agreed on constitutional balance required others to be involved in those same discussions. Mr. Faulkner and Dr. Linder possibly requested from Dr. Sachs, but that didn't happen. So are you saying that what is the breach is not involving other directors?
Deliberately deliberately carrying on the business, carrying on the business while deliberately excluding a director.
When you say deliberately excluding, not involving.
Not involving. Yes.
Do you mean just like Dr. Sachs had done before he departed?
Well, that was chalk and cheese. If the minorities were obviously perfectly happy for the business to be conducted by the jockey they were backing, Dr. Sachs, once the jockey had gone, their only remaining representative was Mr. Faulkner, who was deliberately excluded.
I mean, you say there must have been an express or implied delegation to Dr. Sachs while he was there.
Yes, but by a long practice. Yes, it was. He ran it for years, but that changed once Dr. Sachs had been removed, and And the investors knew not only when they removed Dr. Sachs when they decided to remove Dr. Sachs on the 12th and 13th of March, they decided not only to remove Dr. Sachs for good commercial reasons, but they also decided to sweep aside the Constitution. They decided that thereafter the business was not going to be conducted by the board in accordance with the Constitution. It was going to be conducted by them, excluding Mr. Faulkner. Mr. Fletcher was at the heart of that decision making. He didn't actually make the decision because it was the investors' decision, but he was there advising them and implementing the strategy. It was a strategy that he as a director wholeheartedly endorsed and led. And he led the meeting on the 14th of March, at which Dr. Sachs was removed.
Right. So it's conducting the business or making decisions about the company other than at meetings to which all the directors were invited.
Yes, yes.
Putting it in its.
Yes. I may be making too much of it. Your Lordship may be asking me just to express it rather than.
Well, I mean, the trouble is, I mean, it's sort of good theatre, if you like, to use adjectives and jockeys and all sorts of others. But I'm actually trying to get the legal framework actually a little bit more crisply in legal terms.
Yeah. No, I'm grateful for your Lordship for asking me to express it in that way. I think I may have passed over, and I don't know why, 454. I didn't pass it over because I think I left it for you to read. But I think it's of particular importance, certainly in relation to my Lord Justice Snowden's point about what particular provision was being breached. If you could just read 454. It's the penultimate sentence, the reference to the veto rate, 7.13, which is Article 17.9. So I think it certainly covered 504. I'll come back to the rest of this section as to the reasons for his dismissal. As I will submit, there were no good commercial reasons for his dismissal. Then the directors is 511, but the same point arises, I think, as my lords have raised with me. 522.
What?
And then if you read 522 to 524. My submission is accepted. Breach of Article 14.2. This is under the heading of appointment of further directors. He doesn't accept the way I put it as a breach of 14.2, is 523. I therefore agree that the appointments of further directors mentioned in the matter, which ignored entirely the possibility that the minorities might be entitled to a say in how the business was run, necessarily involve further breaches of the material provisions of section in particular 4.2, 5.2 and 5.3a.
I mean, we've sort of been through 4.2. Were the appointments of the new directors really breaches of 5.2 and 5.3a?
Well, proper corporate governance would have, in our submission, required consultation with the minorities.
But that's because of 4.2. Absent 4.2, there wouldn't be any such duty. Would there?
I think Your Lordship must be right, unless I can, on my feet, I can't.
Yeah. Yeah.
So,
And in the way he goes on to in 524.
you'll see 527.
Sorry.
It's just the last sentence. In fact, was content to ignore it. Sorry, I interrupted you.
So I was actually going to ask you about the previous paragraphs we were looking at in relation to Mr. Faulkner's removal. 511 you took us to. But same 511 and 524, the judge uses the same sort of formulation that well, first of all, he says that the removal of Mr. Faulkner was the same as the removal of Dr. Sachs. He says it was brought about by the investors, not the directors, but to the extent they were involved in encouraging or facilitating the removal, that can only have involved breaches of duty under the Companies Act. Well, why? Can you explain? Can you just, from the perspective of the directors, given that Mr. Faulkner was removed at a shareholders meeting by the investors, where is the findings that support the proposition that the directors were acting in breach of their duty to do what they thought was in the best interest of the company, either in relation to Dr. Sachs, Mr. Faulkner, or indeed in relation to the appointments mentioned at 524?
Well, it's their encouraging and facilitating that removal. Without their encouragement and facilitation, it would not have happened.
I mean, taking the extreme case, and they're not all as extreme as this. If you take 523 and 524, which is the new appointments, I think given the discussion we had a moment ago, the 5.2 and 5.3a don't really feature. So the breach of the shareholders agreement we would be concerned with is clause 4.2.
Yes.
Now, for there to be a breach of section 171, clause 4.2 has to be part of a decision by the company such that it is part of the constitution. And then you find that the investors are acting in breach of clause 4.2, not the directors. But the directors are said themselves to have committed a breach of the constitution because the investors acted in breach of clause 4.2 of something that isn't obviously part of the constitution anyway.
Well, well, I can only adopt the reasoning of the judge.
Well, I'm just trying to understand the reasoning. Actually,
Yes.
I'm just trying to understand what he's actually. It's such a compressed, sort of paragraphs. I'm not sure. I just want them unpicking for me.
But it was formally a decision of the shareholders, but that is in my respectful submission too narrow way of looking at the way the decision to remove Mr. Faulkner was a decision made by the investors when within 5 minutes of Mr. Faulkner having secularized the shareholders for their approval.
And to be fair, having done so on a misleading basis without board approval.
Well, may I come back to that?
Yes.
Because
I mean, the judge says that's understandable.
Yes, yes.
But nevertheless.
In any event, it wasn't, in our respectful submission, a good enough reason to remove him. It wasn't a good commercial reason to remove him as the last remaining representative of the minorities. If that is the test. So here, the judge must be focusing on what happened before the shareholders meeting. And he's looking at the decision that was made that he had to go, which had to be rubber stamped at a shareholders meeting. But the initiative for the removal of Mr. Faulkner came from a body which was operating as if it were the board, but was not the board, and it was being led by Mr. Fletcher. So the breach of duty by Mr. Fletcher resided in the part he played in the decision that he be removed. And hence, that is what, in our submission, the judge must be referring to in the sense of encouraging or facilitating that removal.
Yeah.
And what about the appointments?
Well, there the decisions were made by the board on the face of it. But on the judge's, I think I'm bound to accept Justice Newey's observation that can only have been a breach of clause 4.2. So the reasoning in support of paragraph 5.2.4 is the same mutatis mutandis, is the same answer I would give as I would give in answer to 5.11. If your lordship is focusing on the breach of duty by the directors, how is it a breach? How is it a breach of the Constitution? May I see the time?
Yes.
I'm happy to stop and take that as part of my.
And as I understand it, although we haven't allowed you quite to follow the course you had in mind, we've actually been covering an awful lot of the ground.
Yes, and in a way, I prefer it to come out in that way rather than.
Now, a particular point is we're willing to sit at 10:15 tomorrow. Is that needed?
I have just a minute to think about that.
Yes. Would it be safe to start at 10:15?
Yes.
Yes,
Must
let's do
be.
that.
If you are able.
The other thing I should mention, and as I understand it, this email was copied to those instructing you, is the court has received an email from Mr. de Court writing on behalf of Minden. Have you seen this?
I have.
Yes. It obviously is not his position that Minden is abandoning its appeal. Rather, he apparently has proceeded on the basis that the arguments put by Mr. Gledhill for the other appellants would suffice. Now, I'm not sure what your position in relation to that is. I mean, if your position is, well, that's really not good enough, he can't take advantage of that, Minden can't take advantage of that, then we could possibly raise the possibility of Mr. de Court or someone else from Minden coming to court so as to say on behalf of Minden that that is their position. Is that a necessary step or not?
Well, I haven't had the opportunity of discussing it with my instructing solicitors. In the sense that I suppose there is the question of how we should react to that in our own interest.
Yes.
And I think I prefer not to express any view as to how the court should react.
No, well, I see that point. Perhaps we can leave it overnight. If it were the case, come the morning, that it was going to be your submission that because Minden had not appeared at court, the appeal necessarily had to be dismissed in relation to Minden, then I think I would feel that one way or another, Mr. de Court should be told that, so that there was an opportunity for someone from Minden to come to court to say, we adopt the submissions of Mr. Gledhill or whatever.
Yes. Well, if your lordship is content to leave it with that, you telling me that, which in a sense puts the burden on us to communicate with Mr. de Court, I'm content with that.
Let me just see if.
Yes, and he could come remotely if necessary.
He's not in the UK.
Mr. Gledhill.
I don't act for Minden.
No, I know.
But Mr. de Court is not in the United Kingdom. So if there's going to be some point taken that somebody from Minden ought to attend, realistically, if that decision is only communicated to the court at 10:30 tomorrow morning, it's going to be very practically difficult for that to happen.
I mean, two thoughts occur to me. Perhaps we can leave this till the morning, even though, as you say, there might be time constraints. First, it is actually possible for someone to attend by video link. Now, I know that might take a few moments to arrange, but nowadays we can all use our laptops. Secondly, if Mr. de Court indicated that that were his intended position, it may be that in the exceptional circumstances we could in some fashion arrange things so that he could make an appearance later before judgment was given to make that point. Shall we leave it there then?
Thank you very much.
So we'll resume at 10:15 in the morning. Sorry. Yes. As you'll have gathered, Lord Justice Snowden raises the point, which is obviously a sensible one. At the moment, we're getting the transcripts in by email, which is very useful. But is it possible, please, for whichever side is appropriate, to supply hard copies in a file?
We will do that.
Double-sided, please. And I've
Definitely
already got
double-sided.
yesterday's printed, so save the trees on that.
Most grateful.
10:15.
All right.